So let's take a look at this tribunal hearing between Michael Richardson and the Information Commissioner that took place on September 13th, 2021. Number 1. This is an appeal against the Commissioner's decision FS 5090839 of June 11th, 2020, which held the University of London was entitled to rely on 42 of the Freedom of Information Act 2000. The Commissioner did not require the public authority to take any steps. Factual background to the appeal. Number 2. The appeal relates to President Tsai Ing-wen. There have been speculation in the media about whether President Tsai was correctly awarded a PhD in law in 1984. Request, decision notice, and appeal. The request. Number 3. This appeal concerns the following request made on October 29, 2019. I am requesting the names of the examiners for the 1984 PhD thesis of Tsai Ing-wen. The thesis is entitled Unfair Trade Practices and Safeguard Actions. Please also inform me of the date the examiners signed approval of the thesis. Number 4. The university replied on December 2, 2019, withholding the information on the basis that it was exempt under 42 FOIA because disclosure would breach the data protection principles. Number 5. Mr. Richardson requested an internal review on December 3, 2019. The university upheld its refusal. Number 6. Mr. Richardson referred the matter to the Commissioner on February 5, 2020. The decision notice. Number 7. In a decision notice dated June 11, 2020, the Commissioner decided that the university had correctly applied S40 to FOIA for the following reasons. I won't repeat reasons 8 through 13, which was already outlined in the ICO decision notice. Notice of appeal. Number 14. The Tribunal understands the grounds of appeal broadly to be that the Commissioner was wrong to conclude that there was insufficient legitimate interest to outweigh the data subject's fundamental rights and freedoms. Number 15. Mr. Richardson makes the following points in particular. 15.1. The Republic of China Presidential Office disclosed President Tsai Ing-wen's student record on September 4, 2019. President Tsai Ing-wen has waived her right to privacy and has no reasonable expectation of privacy of her student record. Further, the selective disclosure provides an unbalanced view of events. 15.2. The student record states that she withdrew from the course in November 1982 and does not list her as a student with fees paid or name an advisor for 1982 to 1983 or 1983 to 1984. The date of submission was June 1983. 15.3. The Commissioner did not take account of her own guidance on suspicion of misrepresentation or wrongdoing. 15.4. The Commissioner failed to weigh President Tsai Ing-wen's use of her PhD into the balancing test. 15.5. In applying the balancing test, the Commissioner repeated speculation about the absence of the thesis. 15.6. In applying the balancing test, the Commissioner relied on an IALS index which is not an official IALS record. 15.7. The thesis has not been filed with the LSE Library, the Senate House Library, or the IALS in accordance with academic protocol. An attempt by an unidentified person to file a copy with the Senate House Library in 2011 undermines public confidence that the thesis was properly assessed and raises the question of academic fraud. 15.8. The unsigned copy of the thesis submitted by President Tsai to the LSE Library in 2019 appears to be a draft document. 15.9. The Commissioner speculates that the examiners are alive and therefore subject to protection under the Act. 15.10. The Commissioner has ignored the fact that the LSE released names of thesis examiners to the Wolf Inquiry. 15.11. Releasing the date of thesis approval would cause no more distress to the examiners than the disclosure of the Viva date, which has been disclosed. 15.12. The date is not the personal data of the examiners. 15.13. President Tsai provided consent to disclose personal information in her PhD thesis by email dated June 12, 2019. 15.14. The individuals who approved the thesis must, of necessity, be identified to protect the integrity of the University of London degree. 15.15. To protect the transparency of the university degree process and the integrity of the PhD degree, the question of legitimacy must, of necessity, outweigh any distress the examiners or President Tsai might suffer. 15.16. The examiners are gatekeepers of the university degree, which means that they must be excluded from any personal data exemption. The ICO's response has already been summarized in the ICO decision notice, so I'll skip ahead to Mr. Richardson's reply. Number 21. The Commissioner accepted in the decision notice that disclosure was necessary and has reversed this in the response. Number 22, the fact that a digital version of the copy of the thesis submitted by President Tsai Ing-wen in June 2019 is available online raises questions about the thesis validity and is not the version that was assessed. Number 23, the biographical index relied on is a quasi-official IALS index document and not an official IALS record or communication. Number 24, an IALS email dated October 9, 2019 states that they do not have a copy of the thesis in their collection and have no record that they ever received the copy that was sent to them. Number 25, the Commissioner has relied on the university's assertion without evidence. Number 26, the university's assertions about its library acquisitions of the thesis contradict its email dated October 9, 2019, raising doubts about the veracity of the university's assertions about the thesis. Number 27, transparency mandates verification of the visa examination. Number 28, the Commissioner relies on a 2019 public relations statement from LSE, but they could not issue doctoral degrees in 1983. Number 29, public relations statements and news reports do not constitute academic authentication or verification of the PhD thesis. Number 30, there should be no expectation of privacy and no distress would be caused by the disclosure of the examiner's identities. Number 31, President Tsai Ing-wen waived her privacy by issuing a public statement that one examiner was a law professor and one an economist. Number 32, current academic practice in the UK is to disclose examiner identities. Number 33, the Tribunal has power to make the orders requested. The role of the Tribunal. Number 47, the Tribunal's remit is governed by S58 FOIA. This requires the Tribunal to consider whether the decision made by the Commissioner is in accordance with the law. Where the Commissioner's decision involved exercising discretion, whether she should have exercised it differently. The Tribunal may receive evidence that was not before the Commissioner, and may make different findings or fact from the Commissioner. Number 48, the Tribunal is a creature of statute, and does not have any inherent power to make the orders requested by Mr. Richardson, other than the power, if appropriate, to order the university to disclose the requested information. Discussion and conclusions. Personal data. Number 50. The Tribunal has not been provided with any evidence on whether or not the examiners are alive. In the absence of any evidence to the contrary, the Tribunal finds that the examiners, who were of working age in 1984, are more likely than not to be alive. The examiners' names are information that relates to identifiable living individuals and is personal data of which they are the subject. Number 51. We find that the requested information is also the personal data of which President Tsai is the subject. Taken with the request, she is clearly identifiable from the data. The information has President Tsai as its focus and is clearly linked to or about her because it is the assessment of her PhD legitimate interest. Number 52. We accept that Mr. Richardson has a legitimate private interest and that there is a broader public interest in the legitimacy of President Tsai's PhD. Reasonable necessity. Number 53. We have considered whether the disclosure of the requested information is reasonably necessary for the purposes of the identified legitimate interest. Disclosure must be more than desirable, but less than indispensable or an absolute necessity. Disclosure must be the least restrictive means of achieving the legitimate aim in question, because it would not be necessary if it could be achieved by anything less. We must consider whether the legitimate aim could be achieved by means that interfere less with the privacy of the data subjects. Number 54. The university has not relied on the provision that allows it, in certain circumstances, to neither confirm nor deny that it holds the requested information. The closed bundle contains the requested information. In effect, the university has publicly confirmed that it holds a written record of A, the names of the examiners, and B, the date that the examiners signed approval of the thesis. Number 55. We find that the legitimate interest can be achieved by the university's confirmation that there is a written record of the names of the examiners and of the date that they signed approval of the thesis, and we find that this interferes less with the privacy of the data subjects than releasing the specific date of the names or the examiner. Accordingly, it is not reasonably necessary for the names or the date to be released. Number 56. Further, we find that there is sufficient evidence already in the public domain to satisfy Mr. Richardson's or the public's concerns about whether or not President Tsai was awarded a PhD. without the need to release that particular information. This includes the fact that the university has publicly confirmed that the degree was correctly awarded, and that it holds records of the viva and the pass list in relation to President Tsai, and the fact that the thesis appeared in the IALS list of legal theses successfully completed for postgraduate degrees published in 1985. In our view, it is not reasonably necessary to also disclose the name of the examiners and the date that they signed approval of the thesis. Number 57. Having concluded that it is not reasonably necessary to disclose the requested information, it is not necessary to consider whether the legitimate interests are overridden by the interests of the data subjects, and we find that the university was entitled to rely on the exemption in S42 FOIA. Signed, Sophie Buckley, Judge of the First Tier Tribunal. Date of decision, September 20th, 2021. Alright, so what I can gather from all of this is that the Tribunal Court thinks exactly the same way as the ICO, which thinks exactly the same way as the University of London and the London School of Economics. There is no difference between any of these bodies. In fact, you could arguably say that there is collusion going on between the ICO and the Tribunal Court. The ICO has submitted what they call a closed bundle, which has been cited as evidence by the Tribunal Court. This closed bundle is what Michael Richardson has requested, namely the names of the examiners and the date the examiners signed approval of the thesis. Therefore, the ICO is essentially using the Tribunal Court to prove that these things exist, because they must exist if Tsai has a legitimate degree. But if the contents of this so-called bundle are not revealed to Michael Richardson and the general public, we have no idea if the University of London really does have these records. The Tribunal Court wants us to take them at their word. We saw it, so that's good enough. And the ICO got it from the university. Between the ICO and the Tribunal Court, they do not seem to require very much evidence that this thesis and degree actually exist. In fact, the only real piece of evidence that they cite over and over again is the publication of a reference in the 1985 book of legal theses successfully completed for postgraduate degrees. It's just a reference, and there's so much else missing. This is really a joke from top to bottom in the UK. In fact, I would say that that reference in that book is the main argument of this entire ruling. This reference is the only somewhat legitimate evidence that this thesis might exist. But at the end of the day, it's only indirect evidence, and there is no direct evidence that the thesis exists. So overall, I feel that the ICO and the First Tier Tribunal are ignoring a great deal of evidence that should be there, but is not there. They've essentially ignored all of Michael Richardson's points and continue to repeat the same thing over and over again. An assessment based on a lie is still a lie. There does not seem to be any objective analysis in this report. It's just more of the same, using privacy as an excuse not to release information that should be there for a legitimate PhD degree. Information which they would probably reveal publicly very quickly if they actually had it. But what I can gather from all of this is that it's just a pack of lies, starting with the London School of Economics to the University of London, to the Information Commissioner Office, and now to the First Tier Tribunal, and all this so that Tsai Ing-wen can continue being president of the Republic of China in Taiwan. Let's take a closer look at the ICO decision notice on November 26, 2021. Note that this decision notice is only from the Council of London School of Economics and Political Science. The University of London was already asked for this information, but this notice only came from LSE. Number 1. The complainant has requested the names of the examiners who examined the then Miss Tsai Ing-wen, now President of Taiwan, for her PhD and the report from her viva. The Council of the London School of Economics and Political Science denied holding the requested information. Number 2, the Commissioner's decision is that, on the balance of probabilities, the LSE does not hold the requested information. Number 3, the Commissioner does not require further steps. Request and response. Number 4, On May 2, 2021, the complainant requested information of the following description. In 2019, I made a Freedom of Information request for President Tsai Ing-wen's PhD thesis examiner's names and date of examination. You kindly informed me that Viva examination was on October 16, 1983. However, you declined to answer my question about the examiner's names and dates of signed approval, referring me to the University of London. I have been unsuccessful in obtaining this information from the university, thus I return to you for an answer. I also request a copy of the signed Viva report. Number 5. On May 4, 2021, the LSE responded. It denied holding the requested information. Number 6. The complainant requested an internal review on the same day. The LSE sent the outcome of its internal review on May 26, 2021. It upheld its original position. Scope of the case. Number 7. The complainant contacted the commissioner on May 28, 2021 to complain about the way his request for information had been handled. Number 8. The commissioner contacted the complainant on November 8, 2021. She pointed out that at the time of the exam, the LSE did not have its own degree awarding powers, and therefore any degrees were conferred on LSE students by the University of London. She noted that she had already confirmed that the University of London held the information in question and that even if the LSE also held the same information, it would be exempt from disclosure. She therefore invited the complainant to withdraw his request. Number 9. The complainant refused to withdraw his request and argued that the LSE's denial conflicted with its public statements to the effect that President Tsai's degree had been correctly awarded. Number 10. The commissioner considers that the scope of her investigation is to determine whether LSE holds the names of the examiners and the Viva report. Reasons for decision. Section 1(1) of the FOIA states that any person making a request for information to a public authority is entitled A. To be informed in writing by the public authority whether it holds information of the description specified in the request, and B. If that is the case, to have that information communicated to him. Number 12. In cases where a dispute arises over the extent of the recorded information that was held by a public authority at the time of a request, the commissioner will consider the complainant's evidence and arguments. She will also consider the actions taken by the authority to check that the information is not held, and any other reasons offered by the public authority to explain why the information is not held. Finally, she will consider any reason why it is inherently likely or unlikely that information is not held. Number 13. For clarity, the commissioner is not expected to prove categorically whether the information is held. She is only required to make a judgment on whether the information is held on the civil standard of the balance of probabilities. Number 14. The commissioner has issued numerous decision notices concerning President Tsai's PhD award. These decisions record some of the background and controversies about the degree, and the commissioner considers it would serve no useful purpose to repeat them here. Number 15. The LSE reiterated in its response that in 1984, when the degree was awarded, all LSE students received their degrees from the University of London, as it did not have the power itself to confer degrees. The University of London was responsible for arranging and invigilating any examinations, and the LSE would receive a notification confirming that a particular student had been awarded a degree. Number 16. The LSE accepted that it did not still retain President Tsai's student record, but that record only dealt with her activities at the LSE, and this did not include details of her final examination or Viva. Number 17. The student record had been examined and no definitive record of the examiners had been found. Whilst one document indicated that a particular individual might have been an examiner, the LSE had no way of cross-checking whether that individual had in fact performed that role, and the LSE considered it unlikely that they would have done so. Number 18. The LSE was satisfied that no relevant information had been destroyed, and that the reason that it did not hold the information now was that it had never held the information, because the information was held by the University of London. It had been able to confirm the authenticity of the degree based on the copy of the notification it had received from the University of London in 1984, confirming that President Tsai had been awarded a PhD. The Commissioner's view. On the balance of probabilities, the Commissioner is satisfied that the LSE does not hold the requested information. Number 20. The arrangements between the LSE and the University of London were different in 1984 to how they are today. As the degree awarding body, it is logical to consider that it would be the university that has the records pertaining to President Tsai's examination. And the commissioner has already established that these records are, as a matter of fact, held by the University of London. Number 21. The LSE has searched its records and has been unable to locate the information in question. In the commissioner's view, the most likely explanation is that the LSE has never held this information. She is satisfied that none of the LSE's statements to which her attention have been drawn conflict with the denial that this particular information is held. Number 22. The LSE has drawn the commissioner's attention to a document which might indicate who one of the examiners was. The LSE is not required to confirm whether this individual did in fact act as an examiner, unless the information is already in the public domain, which it is not, as this would require it to acquire new information that it does not already possess. Even if the LSE was able to confirm that this individual was an examiner, as the commissioner ruled in decision notice FS5 0908339, the LSE would be entitled to rely on Section 40 of the FOIA to withhold the name anyway. However, as the LSE does not hold the information in the first place, no exemption is necessary. Number 23. The Commissioner is therefore satisfied that the LSE has complied with its obligations under Section 11 of the FOIA, as it correctly informed the complainant that it did not hold the requested information. Number 23. The Commissioner is therefore satisfied that the LSE has complied with its obligations under Section 11 of the FOIA, as it correctly informed the complainant that it did not hold the requested information. So the gist of all this is that it was normal for the London School of Economics not to have any record of the Viva examination, and that the University of London had them all along. This Freedom of Information request was already made to the University of London long ago, but they chose to respond with the London School of Economics. Now, why is that? By responding like this gets LSE off the hook legally. They can just simply pass the baton to the University of London and say that they didn't have it all along, and therefore the London School of Economics verified that she got the degree legally with their other records. They're not claiming that they don't have any records at all. They're just saying that they don't have these records regarding the Viva examination. Or rather, they're claiming that the Viva examination took place because the University of London has the records, and they're taking the University of London's word for it. So in other words, we're pretty much in the same place. There has been no progress made legally as far as finding out the truth of whether or not Tsai Ing-wen legally got this PhD degree or not with a thesis, simply because the London School of Economics and the University of London are saying that they have such and such documents and that the thesis existed before but it doesn't exist now, as if that makes any sense at all, especially considering the fact that they have all of their graduates' thesis papers in the Senate House Library from that period of time. None of them have been lost. All of them are searchable, and they're all there. Yet somehow Tsai Ing-wen's thesis is missing from 3 different libraries all at the same time, but yet they want us to believe that it existed at some point simply because there's a reference from some book printed in 1985. So in other words, Tsai Ing-wen, the London School of Economics, the University of London, the ICO, and now the first-tier tribunal all have deniability in this case. It's not believable. And of course they know it. Saying that they have records that it existed when their own computer records in the Senate House Library says it was never turned in is pretty much a lie. It's like committing perjury. On top of that, they won't release their so-called records that confirm that the thesis existed in the first place. There's absolutely no evidence that this thesis ever existed, and yet they keep saying that it existed before. And the physical copies were lost. There is no acknowledgement that the card catalog system in the Senate House Library doesn't show that it was ever turned in. They just rationalized that it was turned in. So we're pretty much dealing with a full-blown scandal that ranges from the Republic of China presidential office to both schools, the ICO, and the Tribunal Court. There's absolutely no admission here that Tsai Ing-wen's PhD thesis was faked.
2019年10月31号 ，Michael Richardson 首先去函询问了 LSE 蔡英文 Viva 口试委员到底是谁。LSE 的 Information Record Manager 是这样回复 Michael Richardson 的，他说：“我们相信记录都保存在伦敦大学，但是教务处确实在1984年的2月8号发出认证，并且在1984年的3月14号颁发了学位证书。”
Elizabeth Denham from the Information Commissioner Office has recently resigned. Let's recap everything that happened with the University of London and the ICO. January 26, 2020, University of London Internal Review refuses to name Tsai Ing-wen thesis examiners claiming Privacy Act exemption from public disclosure. We haven't forgotten about you, Rosalind Frendo, Secretary of the Board of the University of London. February 5, 2020, complaint filed against University of London over Tsai Ing-wen thesis secrecy. Elizabeth Denham, Information Commissioner for the United Kingdom, to rule on University of London's non-disclosure of Tsai Ing-wen's thesis examiners. March 23, 2020, Information Commissioner's preliminary finding is that release of PhD thesis examiner's identity likely to cause damage or distress to Republic of China President Tsai Ing-wen. April 23, 2020, University of London deluged with questions about Tsai Ing-wen's thesis. Rosalind Frendo, Secretary to the Board of the University of London, is tired of answering questions about Tsai Ing-wen's 1984 thesis. June 11, 2020, Information Commissioner claims Tsai Ing-wen's thesis lost during remodeling. Elizabeth Denham, Information Commissioner for the United Kingdom, says Tsai Ing-wen's controversial 1984 thesis was lost during library restructuring. July 17, 2020, Information Review Tribunal to consider restricting appeals to only United Kingdom residents over Tsai Ing-wen thesis secrecy by University of London. July 30, 2020, Information Review Tribunal puts ruling in Tsai Ing-wen thesis secrecy case on hold. September 22, 2020, Information Commissioner Elizabeth Denham argues for President Tsai Ing-wen thesis secrecy and freedom of information case and ridicules members of public seeking truth. The Commissioner finds it somewhat difficult to describe the fake thesis/degree theory as it lacks coherence. In broad terms, the theory alleges that the university or the LSE, the corrupt institution, varies from allegation to allegation, conspired in 1984 to award the then Miss Tsai a PhD to which she was not entitled, presumably for the express purpose of manipulating the Taiwanese presidential elections of 2016 and 2020, and is now trying to cover its tracks. Another alternative theory is that the PhD was never conferred, and President Tsai has simply invented it. According to this version, the LSE and/or the university have conspired to fabricate the original records and the degree award, to either curry favor with the government of Taiwan or to increase their own prestige by associating themselves with the head of government. February 24, 2021, British court rules Freedom of Information lawsuit over Tsai Ing-wen thesis may advance and orders Information Commissioner to notify University of London. March 27, 2021, President Tsai Ing-wen privacy more important than verification of University of London degree, says Information Commissioner. May 19, 2021. University of London intervention in Freedom of Information case by obfuscation of President Tsai Ing-wen's commercial and employment use of PhD, and speculation about our missing thesis raises question. September 21, 2021, United Kingdom Court upholds University of London secrecy over Republic of China President Tsai Ing-wen PhD thesis examination. Republic of China in exile President Tsai Ing-wen's PhD thesis, and United Kingdom Information Review Tribunal Judge Sophie Buckley, who ruled the University of London did not need to identify the examiners who approved the thesis. Farewell, Commissioner Denham. We won't be missing you.
Questions loom large about Taiwan president academic credentials.
Yeah, this one has to do with her PhD, whether it was legitimate or not. Here's the thing. I digged into whatever I needed to dig into and contacted whomever I needed to contact. I did confirm that she did indeed attended Cornell University. Okay, for the PhD part, which the record, based on what she's indicating, that she received the PhD from the London School of Economics back in 1984. I am still waiting for a confirmation for that. Well, so as it stands now, her credentials from Cornell University checks in.
Okay.
So we're waiting to confirm the one about the PhD. And we will let you guys know.
我们今天早上的记者联访就先到这边，因为我们的时间还有限。但当初国民党也是打你这一块，就他们自己好像也都没有办法。
这件事情哦，这个现在大家也都知道了，这个 时间久了，很多东西就是在要去找出来，确实是有困难的了哈。那这个好啦，我只能对我自己的事情讲清楚了。我的论文没问题，我的学位是真的啦，好，那不要在这事情上做无谓的文章。